free to type in questions along the way, and we will be addressing those either throughout the program when the issue comes up, or we will address all questions at the end. My name is Lisa Dillman. I'm an elder law attorney in Indianapolis and work a lot with veterans and their families in planning for VA benefits, as well as pre-planning for asset protection and things like that. So these changes directly, or proposed changes, I should say, directly impact a large part of my clientele. So that's why we wanted to get the word out, not only to our existing clients, but those folks who are thinking about making a move and want to explore veterans benefits, so we know what these changes, what kind of impact these changes may have. Also joining me is Carlotta Catra. She is a VA accredited agent, and you may know her from Senior Care Advisors. She works with many facilities and veterans to develop eligibility for the aid and attendance benefit. She will be taking the questions that you send in, and will be making sure that she'll moderate those questions and make sure that everybody gets answers. Basically, the background that you need to know at this point is Friday evening on January 23rd, the VA published on the Federal Register proposed rules that will directly impact eligibility for the aid and attendance pension. We will talk about what is happening procedurally and timing-wise, and how those changes will affect existing clients and future residents who need the VA benefit in order to defray the cost of assisted living. We will also share with you what is happening on the national level for a coordinated national response to these rules, proposed rules. I've also been very active, as has Carlotta, in a grassroots local response as far as getting the word out, social media, trying to reach our Congress people, and you'll be surprised when we reach out to our senators and our congressmen about these changes. Their office is telling us they had no idea that these changes were being proposed, and they want us to educate them and to tell them what's going on so then they can make a response on behalf of their constituency. We will end the program with, what does that mean now? What does that mean for people who have pending claims? What does that mean for people who want to become eligible for the VA benefit in order to pay for long-term care? So basically what is happening at this point is, as I mentioned, the VA published this proposed rule change on January 23rd and basically offered a 60-day comment period. They are required to offer a chance for public comment under the Administrative Procedures Act, and they have done so. That means that everyone and anyone can post a comment and let the VA know what they think about this rule and whether they see that the rule is going to cause problems or whether they agree with the rule. The biggest thing that needs to come out of this 60 days is the VA has to hear from the media, from Congress, from veterans, from facilities, from practitioners. They have to hear from as many people as possible as to how the proposed changes will negatively impact veterans and their payment for their care, because the ultimate purpose of any rule promulgated by the VA is to protect veterans. So let's take a look. Right now, there is no accounting for or no opportunity for public hearing. However, if there is great outcry, which we anticipate there will be within the 60-day comment period, under the Administrative Procedures Act, we may be able to have a chance to go public hearing. If we go that route, it's likely that the proposed rule changes would be taken up by Congress, and it would then be pushed into a legislative effort rather than an administrative effort. And I know this sounds like a lot of legalese, but it's important to understand this. When the VA makes a rule, that means they can effectuate change without going through the process of lawmaking, without having to propose a bill in Congress that has to make it through the House and make it out of the Senate. This is important because over the last couple of years, bills that have included changes like those that are proposed by the VA in this proposed rule have been defeated by Congress, that they could not get enough votes on the floor in order to effectuate this change. So now for the VA to come and try to do the rulemaking procedure rather than the lawmaking procedure, we've got some constitutional issues that we're going to have to deal with, due process issues that we're going to have to deal with. So those are the kinds of issues that the lawyers are framing their comments around. But what's important is that we get comments out there that talk about the individual veteran and how that's going to affect the people, the individuals who will not have this money to pay for their care. The stated purpose of the rule is to establish new requirements pertaining to the evaluation of net worth and asset transfers. This boils down to that 3-year look-back period that we've known is the VA wants to impose. We know that it's coming down the pike at some point. It'll be a question of when and how it's imposed, and that is basically what the rule is trying to accomplish. The rule also says that the change wants to identify those medical expenses that may be deducted from countable income. This is very important because it directly impacts what expenses would be countable in order to determine eligibility for the benefit. This is going to impact assisted living facilities, in-home care professionals, independent living facilities. The VA also indicated that they're trying to propose these rules in response to recent recommendations made by the Government Accountability Office. You may or may not know that in 2012, the GAO issued a report that was scathing, actually, and it concluded that there are many people out in the industry that are trying to take advantage of veterans and trying to make money off veterans in order to get this benefit. The GAO's report was aimed primarily at what they called pension poachers, and those were people, financial brokers, who were selling very punitive annuities to seniors. They were selling annuities to people who were 85 years old with a 15-year surrender penalty and tying up their money, and the GAO found out about this and responded very aggressively. Well, the VA is using that report to try to effectuate these rule change, and what they're ignoring are all of those professionals, those VA-accredited agents and VA-accredited attorneys out there that are actually helping veterans and their families become eligible for the benefit, and also look ahead in case those veterans or their spouses need Medicaid benefits in the future. So while they say they're responding to the GAO's report, it's not entirely accurate of what's happening out there in the real world. Bottom line, though, the mantra or the flag that they are raising, the VA is raising, is that they want to maintain the integrity of the program and make it a needs-based program. They recognize that there has been no prohibition in the past that allows transfers of assets to do VA benefit planning, but they want to try to effectuate change that's going to make it more needs-based. That being said, this reminds me of several years ago when the DRA was enacted, and when you could still get Medicaid by making transfers on Monday and applying for Medicaid on Tuesday. Medicaid implemented a 3-year look-back to begin with, and then a 5-year look-back. All that did was change the way people could plan. It's not as easy, it's not as quick, but long-term care planning was still necessary and will still be necessary even if these rules are enacted, because seniors need to have the funds to take long-term care all the way, both for the veteran and the veteran's spouse, and that can't be done under the current proposed rule changes. So let's talk about in my estimation, the top 10 most concerning changes that when we are all issuing our comments to the VA, we want to make sure that we touch on these particular things. Number one, the VA is saying they will impose a transfer penalty for transfers of assets that occur prior to application. The transfer penalty cannot exceed 10 years, but you can't cure the gift that caused that transfer penalty. So even under Medicaid rules, if there's been a transfer of assets, you can cure that transfer of assets by giving it back and not having a transfer penalty. The VA has imposed a very cruel 10-year penalty, and they say you can't fix it once you've done it. This change right here is going to be one of the focuses of my comment, because you can't assume, or I'm going to ask the VA not to assume that if someone gave a gift to a child, $50,000 to redo their basement, and when they need care 2 years later, they apply to the VA, and the VA says, no, you gave away $50,000, so you're going to be penalized. But why can't I have a chance to fix it? Why can't I have a chance to give back that $50,000 so then I can become eligible for benefit? The other thing that's difficult about this proposed change is that they do give a grace period for you to cure it. However, it's within 30 days of application. The VA doesn't process applications within 30 days. So your window within which to cure the gift has closed before you even know whether the VA is thinking about denying you for that transfer or penalizing you for that transfer. In practicality, or in practical terms, the transfer penalty is extremely cruel for veterans, and even more so for their surviving spouses. Let's look at this. The transfer penalty for a veteran is divided by, the amount that they give away is then divided by the amount they would receive in benefit. So if they give away $100,000 and they would have received a benefit of $2,120, they're penalized for 47.16 months. The reason this is skewed, in my opinion, is because even when you are looking at a Medicaid penalty, Medicaid uses as its divisor the amount it costs to pay for care for 1 month, not how much Medicaid pays for that benefit for 1 month. So it's using how much of the money the veteran would get as the divisor rather than how much the care would cost as a divisor. But if that wasn't bad enough, if there is a surviving spouse, a widow, that has a $100,000 transfer, their divisor is only $1,149. Now that 47-month penalty is almost doubled. It's an 87-month penalty, and basically her ability to get the VA benefit, his or her ability to get the VA benefit at that point is foreclosed, because they wouldn't be able to get that additional money to pay for care. Maybe she is no longer able to stay in assisted living and would have to prematurely go to nursing home care, even if she's not quite ready for it, because nursing home care would be the only place that she could get Medicaid assistance. So it really is limiting access to care and dissolving a lot of options for seniors. The second thing that I think, the second most grievous proposed change, is there's no mention of a grandfather clause. The proposed rule does not say when the changes will go into effect. It doesn't tell us what impact it will have on pending claims, and it doesn't tell us what impact it will have on benefits that are already awarded. This is a basic, in my opinion, this is a basic constitutional issue that you cannot enact a law and apply it retroactively when people thought that they were following the rules, or at least not violating the rules. So that's another thing that we're going to be advocating for very vigorously, is that if you are going to impose a look back, and we understand if that's going to be the ultimate outcome, we'll find ways to continue to plan. But if you're going to impose the look back, then you need to do it in a fair manner. And that is, tell everybody when the rules are going to go into effect and not just wake up one day and find it on the Federal Register, and then also allow for a grace period. The bills that were defeated in the Senate over the course of the last couple of years provided for just that. They said, we want to impose a 3-year look back. We want to make the new rules effective on X date, and we will give you a 365-day grace period, so any planning that had already begun or was in process could conclude under the old rules, because that's what you believed was in effect or what governed your actions, and then going forward you will have noticed that the new rules are in place. That's extremely important, and obviously my number 2 change that I think is not fair. Right now, the VA's predicted effective date for the rules going into place is October 2015. However, I believe, and practitioners across the country believe, that this proposed or predicted effective date is extremely premature, because what the VA has to do is they are required under the Administrative Practices Act to respond to every single comment that is submitted to them during the public comment period. So, and we believe the comments that will be submitted over the next 60 days before March 24th, 2015, we believe the sheer volume alone will not allow the VA to have processed those comments by October 15. And in fact, a recent conversation that I had with the public policy chair of the National Academy of Elder Law Attorneys said, realistically, the VA won't be able to get through all of the comments for at least a year. Not only does the VA have to process all the comments, they have to incorporate their response to all of the comments in their final rulemaking. So, not to say, let's say that 1,000 people submit comments on how unfair the transfer penalty is. They can make one response to all the complaints about the transfer penalty, but they have to go through every single comment on that topic and make sure that their proposed rulemaking addresses every single aspect of the transfer penalty that was commented upon. The other thing that is going to push that effective date back is that we have evidence of congressional intent, and that congressional intent was to give everyone a 1-year grace period. VA's rulemaking power is limited by congressional intent, and if there is an ambiguity as to Congress's intent, by statute, the ambiguity gets resolved in favor of the veteran. So tie goes to the runner, to the veteran. So that's why we think that this effective date at the very earliest would be October 2015, highly unrealistic, and we believe that it would not only go into effect at least a year from now, but that we believe that another year grace period would be stacked on top of that. That being said, we're not sure about anything at this particular point. So we are reaching out to all of our clients, all of our potential clients, or anyone that's inquired about VA benefits in the last couple of years, to tell them about this rule change and to encourage them, if they are going to make a move, let's make it sooner rather than later. Let's get the planning done and at least beat the October 15th deadline, the October 2015 deadline, and then we will know a lot more by then regarding the timeline of this proposed rule change. The other thing that may happen to push this back, just quite practically, is when we spoke to the VA rulemaking body, they have a help desk, and so we called the help desk and said, hey, listen, we've got 60 days. Is that ever extended? Do people get more time? And the response was, yeah, we give more time all the time. we usually extend the comment period by 90 days when a proposed rule draws the attention of the media, when there are a volume of comments that are submitted, or when we start hearing from Congress people. So that's why it's imperative that we start getting the word out and have those outlets those people contact the VA and say, listen, we need more time. You can't sneak this proposed rule change under the door this quickly. So that may also be working to lengthen the time of when any proposed rules would go into effect. Number 3, this change is upsetting. Right now, the proposed rule indicates that you cannot rebut the presumption that a transfer was made for the purpose of becoming eligible for VA benefits, unless you can prove that you were defrauded, someone made a misrepresentation to you, or you were a victim of unfair business practices. That is in direct response to the GAO's report finding that there were people helping veterans become eligible for VA benefits by transferring all of their money into very punitive annuities. That's why you're allowed to get out of your transfer if you can prove that you were a victim of that. However, for most of us will have be potentially hit with a transfer penalty because we've given to our church regularly, because we've given Christmas gifts to our children and grandchildren, because we've spent money helping our family through bankruptcy or a foreclosure or a period of unemployment, or because I've given to charity for any particular reason. Any other innocent purpose that had absolutely nothing to do with becoming eligible for VA benefits, those are penalized because you can't prove that they were made under fraud, misrepresentation, or unfair business practices. So to me, the proposed rule as written that does not allow for the ability to rebut the presumption that I made a transfer for a completely different reason. 2 years ago, I gave my kid $50,000 for college, and I need care now. I'm going to be penalized for that, and had nothing to do with the VA benefit. So I think that needs to change. The proposed rule also does not allow for any exempt transfers. And you'll want to know that the proposed rule talks a lot about how it wants to fall in step with Medicaid rules or fall in step with Social Security rules. Yet it greatly departs from those rules in some really critical places. Medicaid allows, for instance, for you to make exempt transfers for prepaid funeral trusts, for disabled children or grandchildren. The VA rule does not allow for these types of transfers. So it's basically discouraging you to do planning to pay for your own funeral or to help take care of disabled family. And that's certainly not congressional intent. And that will be the focus of quite a few comments, I'm sure. But what may be even more disturbing is because the proposed rule change doesn't have precise language about trusts. They just make a general prohibition about transfer to trust. If you transfer to trust, it's going to be a violative transfer. They don't make any distinction between an irrevocable trust or a revocable living trust. And many, many families use revocable living trusts as estate planning tools to stay out of probate court. So conceivably, as it's written now, the VA could penalize a family for doing estate planning that has nothing to do with becoming eligible for the VA benefit. So the way they've defined transfers to trust, it's imprecise. It leaves it's too restrictive because of its imprecision. So those kinds of definitional terms will need to be addressed as well, so people don't unwittingly back into a transfer penalty. I say they don't allow transfers to disabled children or grandchildren. Under one exception they do, and they define it so restrictively that I don't see many of our clients, our senior clients, being able to fall under this exception. You may make a transfer to a child who is, quote, permanently incapable of self-support, and that disability had to occur prior to the age of 18. I have several clients that have in their plan that has worked to become eligible for the VA benefit have also made provisions for their adult child who has been in an accident and is permanently disabled. But because that adult child wasn't in that accident until they were in their 40s or their 50s, this provision would not allow for transfers to help take care of disabled adult children. That can't be congressional intent, and that's just another byproduct of some imprecise drafting. The fifth thing that I think needs to be addressed is right now, as read, it would require facilities to be licensed in order to dispense care. Otherwise, those facility expenses would not be counted toward unreimbursed medical expenses. The reason for this, or how this plays out, is the way they've defined healthcare provider. They propose to require that an individual be licensed by a state or country to provide health care in the state or country in which the individual provides the health care. The way I read that, and the way many practitioners are reading it, is unlicensed assisted living facilities currently dispensing care and having that count as an unreimbursed medical expense for purposes of becoming eligible for the benefit would no longer be able to do that. That is a big, big problem. That means the access to assisted living care for veteran clients will be extremely restricted. Their options will be diminished, and it will create just a skewed supply and demand. So that needs to be addressed as well. Residential facilities must be staffed with custodial care providers 24 hours per day. That's another proposed change that they're making under this licensing requirement. In order for a facility to be included in our definition, it must be licensed if such facilities are required to be licensed in the state or country in which the facility is located. With this language, that tends to suggest that maybe we can argue that if Indiana doesn't require an assisted living facility to be licensed, maybe the VA shouldn't either. But I will tell you, if we just let this change go and let this language stand, we will be wrapped up in appeals for our veteran for years, and they will not receive the benefit. So this needs to be, this potential contradiction, internal inconsistency needs to be addressed right out of the gate with respect to this proposed rule. Again, it's going to really impact what is out there for veterans, consumers of assisted living facilities and their services. It's going to restrict their ability to get the care they need. However, the proposed rule change suggests that the VA may be lightening up on independent living facilities. Assistance because a person with a mental disorder is unsafe if left alone due to the mental disorder. This language is suggesting that if for instance, an Alzheimer's patient lives in independent living and can do their own bathing and dressing and food prep, they just need to live in a protective environment. This language is suggesting that now the independent living facility may be bootstrapped into that unreimbursed medical expense, the rent and room and board. So if that's the case, then we absolutely want to comment on this piece to encourage that they adopt that portion. At least I do, because I've always felt that it's not fair that a person has to go to a higher level of care in assisted living than they really need just to get the room and board to count as the medical expense. So this is an opportunity for folks to really age in place and to take advantage of the continuum of care options that are out there. And the VA seems to be supporting that, but we'll see. The sixth change that will affect so many of my clients is how they're counting the home place, the primary residence. Right now, the proposed rule language seems to relax some of their interpretation from before. Now they say the primary residence is exempt no matter what. It doesn't matter if you're not living in it. It doesn't matter if you're renting it out. It's exempt. Right. Currently, they would have a problem if you weren't living in it. Sometimes they try to scoop that up into net worth. Sometimes they try to show that a primary residence that's been converted into a rental property should be counted as net worth. So they make it clear that the primary residence, no matter what state it's in right now, is exempt, up to 2 acres. So if your home, if the veteran's home sits on a lot that is 2 acres or less, it's exempt for any reason. What about family farmers that have been farming 100-acre farms for 150 years? Do they now have to start sectioning off their acreage and selling it in order to get their net worth down to be able to qualify? Extremely punitive, especially if they've got adult children that are working that farm, but the farm's just not titled in their name yet. So there's a lot of planning that needs to be done with respect to clients who have family farms. There are things that we can do to make sure that the family farm is documented as a business concern, as a going concern, rather than as a primary residence. And it's those kinds of planning tools that hopefully we can save the farm and still get the senior the care that they need. What's unfair about the 2-acre limitation is that they pulled 2 acres out of the 2012 report that said, on average, new home buyers buy homes with an average lot size of 2 acres. I don't know about you, but my clients aren't new home buyers. They've been in their home for 20, 30, 40 years. Some of them were born in the home and still live in the home. So this 2-acre average in the 2012 report is not accurate. It doesn't speak to the veterans that they're trying to help. Oh, I got ahead of myself. I'm sorry. Here's something else that we need to address. The primary residence is exempt until it's sold. If the family has to liquidate the house in order to pay for care, or because they just can't keep up the house anymore because they're in assisted living, and they sell the house, the proceeds are now counted as a countable asset unless the new home is purchased within a calendar year. 2 things are wrong with that. Number one, what if I sell my house in December? I have 30 days to purchase a new home because it has to be done within the calendar year. I think that needs to be changed. It needs to be within 12 months. But more importantly, these proceeds that could knock a veteran off benefit and trigger an overpayment request. So we need to be working with families who have homes to make sure that we can protect that home under asset protection planning, such that when they do need to sell the home, we can protect the proceeds, and the proceeds can be sitting there waiting to help pay for care along with supplementation with the VA benefit. The next change that needs to be addressed is an annuity that a senior currently has that has a 0 cash value. That means they can't get their hands on it. They're going to start counting that as an asset. This change violates the VA's own rules, their own regulations, and the United States statute. There are several statutes that talk about how you can value an income asset. So basically, when an annuity is annuitized and turned into an income stream, the statutory authority right now says the VA can't make this change. Great. The lawyers will argue that. But for a practical effect, let's say that there's a veteran who needs the VA benefit to help pay for him and his wife in assisted living. He has an IRA that would be counted as an asset in his column. He wants to convert that IRA into an income stream. That IRA then has no cash value but will give him income for the rest of his life. The VA should count that income stream as income, but should not count the corpus of that annuity as an asset. That is the practical effect of how it's going to hurt veterans. Veterans who either already have annuities in place and can't touch them, now they're getting counted assets against them that they don't have access to liquidate and pay for care. Or they can't do planning to allow them to increase their income stream to pay for care as time goes on and allow the benefit to supplement that income stream. Currently, the proposed rules do not have a hardship provision. Medicaid rules have a hardship provision. Social Security rules have a hardship provision. Most benefits-based legislation all have hardship provisions. The upshot of how this is going to hurt our veterans is that if they have made a transfer in the past and they're not able to rebut the presumption that they didn't make the transfer for purposes of becoming eligible for VA benefits, they can't fall back on a hardship provision and say, listen, I gave my $50,000 away 2 years ago. I didn't know I was going to need care. I don't have any money to pay for care, and you're not going to give me the benefit to help me pay for care. What's my option? My option is I have to go to a nursing home prematurely. This really may have a devastating impact for seniors who, let's say they transferred their home and had to liquidate it. And so let's say they transferred it into a trust, liquidated it, has spent the proceeds on care, and they really need the benefit to help supplement that care so their money can go longer. The VA penalizes them for the transfer of that asset. Now they can't pay for care, and they don't have a home to go back to. There has to be a hardship provision built into this legislation, if for no other reason than to take into effect just the human stories that are out there that people sitting in an office in Washington can't predict when they're trying to draft either legislation or rulemaking. None of us can think of every single contingency that may happen to a family, and that's why you build in hardship provisions. The number 9, what's not clear is how the VA is going to look at its new net worth limit. The VA says if you have $119,000, you can still become eligible. So you can have net worth of up to $119,000. But that 119 also includes income. But that income is netted out against medical expenses. So let's do a simple calculation. Let's say that our veteran's family has $100,000 and they have $50,000 in income with both Social Securities, 2 pensions, and whatever else may be coming in. So the $100,000 in assets plus the $50,000 in income puts them over the net worth limit of 119. However, what if the veteran and spouse have $35,000 in medical expenses? They can net their $50,000 of income out against the $35,000 of medical expenses, and now they're down to 115 and perhaps within the new net worth limit. We don't know if that 119 is applicable to the veteran only, or a married veteran, or a surviving spouse. We don't know if that 119 is across the board applicable. We also don't know whether the VA is going to take that 119 and compare it to the shortfall every month for medical expenses and say, okay, veteran and spouse, you're falling short every month $2,000. Your income doesn't cover your medical expenses by $2,000. And you have $119,000 in assets. $2,000 shortfall over how many years will it take for you to erode the 119? Will that cause that veteran and his family to get a denial, or worse, to get that application buried under a big stack of applications because the VA knows, oh, they've got the 119. They can hang on for quite some time. So, and I'll tell you, that's exactly how the VA has applied their prior asset limit. The VA publishes that you can have $80,000 in assets for a couple, and then we've had to extrapolate that if it's only single, then they only get to keep $40,000. But the VA absolutely looked at the shortfall as compared to that asset limit. Is that what's going to happen here with the 119? It's just not written. It's just not publicized because that's exactly how they interpreted the old net worth limit. So there's going to be quite a few questions. And number 10, this 3-year look back. First of all, is that something that we want to advocate to change, or do we want to use that imposition of the 3-year look back to leverage all of the other changes that we want? Basically say, okay, 3-year look back, it's coming, we're fine with that, but we need a better transfer penalty, we need a grandfather clause, we need to understand how annuities will be treated, the home place, and so on and so on. So the 3-year look back, while some people may advocate that, no, a 3-year look back's not fair, and that may be the spirit of their comment, I know right now that's not going to be the spirit of my comment. But I will tell you, and I've had conversations with my clients in the last several days, and, you know, I have a World War II veteran that said it very articulately. He said, you know what? When I got out of the service, they said they'd take care of me when I'm old. I'm old. I want to be taken care of, and I shouldn't have to worry about a 3-year look back. So there's some merit to his argument. You know, he was promised things, and what he's really concerned about is if he goes first, will his spouse be penalized because of prior transfers, prior planning, and will his spouse not get the promise, the benefit of the promise that was made to him? So there's arguments both ways. Regardless of what happens, even if a 3-year look back is put into place, just like when they put the 3-year and 5-year look back into place with Medicaid, there are still planning tools available, still strategies for getting people eligible. I will tell you, while I hate many of the proposed rule changes, it does give me some comfort that when it was so easy to become eligible just by making certain transfers, anybody could have advised a veteran and their family what to do, and 9 times out of 10 they'd be successful. These rules will ensure that a veteran and their family has to seek out counsel with a VA-accredited agent or a VA-accredited attorney to help them understand how to comply with the rules changes. So in that manner, I think ultimately the GAO's report will be addressed, that we're getting people out of the veterans benefits business that really didn't have the veterans' best interest in mind, and they'll be relying on counsel just like they do in the Medicaid arena to help guide them through the process and get them the benefits that they deserve. I wanted to share with everyone kind of what we're doing on a national level and what you can be doing and your residents can be doing on a local level. No matter what, whether our voice is local or whether it's national, we have to consider what is needed. We need a volume of comments. We need a volume of people reaching out to their congressperson or their media, local media outlets, and not even, you don't even have to advocate one against the rule. All you have to do is say, hey, do you know that this proposed change is being put forth, and do you know that how badly it's going to impact veterans? That right there will get them alerted, and they'll educate themselves. And I will tell you, just like I mentioned before, there are several media outlets and congresspeople that were taken aback that they didn't know this change was out there because they've been involved in defeating the prior 2 bills on the Congress floor, and they were upset that the VA tried to sneak this rule in under the door. So we need sheer volume. That being said, the volume has to say something. It has to address the specific things in the proposed rule that the person doesn't like. A comment will not be well received by saying, hey, the proposed rule stinks. It's just, that will not make an impact. But if there is a particular part of the rule that is particularly offensive, that's what your comment needs to be about, or your multiple comments need to be about. But from everything that I've heard nationally, working with American Legion, VFW, National Academy of Elder Lawyers, the most important voice that the VA wants to hear is the veterans. So if you can encourage your residents or your clients to sit down and tell you a story that how that benefit has impacted them or saved them or allowed them to keep their family farm, and you can help them write that comment out and submit it, that will speak volumes to the VA. Those are the kinds of stories that the Senate and the House of Representatives will not ignore. So we have to get the right voice out there. Now, granted, lawyers are going to put comments in, facilities are going to put comments in, national federations of facilities are going to put comments in. Yes, we should be heard. We need to be heard. We represent our clients and our residents, and we need to advocate on their behalf. But it also needs to be acknowledged that, are we fighting so hard because, you know, it's going to hurt our census or it's going to hurt our clientele base? Are we fighting because we're going to lose a portion of our job? I think the VA will absolutely read our comments with that bias. That's why it's so important that we narrow in on the substance and we read that proposed rule and think about how, if this is enacted as written, how it's just going to be a mess for those families. That makes our comments more human and more about the client and less about livelihood or whatever bad motivation that's being attributed to us. Like I said, the national media is being talked to, reached out to. AARP, the Alzheimer's Association, has tons of veterans. So if you have local chapters that you can reach out to and let them know what's happening, that would be valuable. The National Academy of Elder Lawyers has a lobbying group, and we'll be putting together a comprehensive comment as well as talking to certain members of Congress and working committees in the House. The American Legion, both nationally and all of your local chapters. If you can reach out to members or leaders at the local level that this is happening and that it's a problem, just to educate them so they know that something's happening and it's not just snuck in at the 11th hour. Same with the VFW. What are we doing at a local level? We are writing, emailing, and calling our congressperson. We have, at my law firm, and I know Carlotta has as well, we have sample letters that you can use, skeletons of letters that you can kind of use as the basic layout, and then you can add your own experience or your own particular problem with the proposed rule. So we can absolutely make those available to you and your residents, and we would be happy to do that. Call your media, do a press release, call your local paper. Even if it's just picked up by local outlets, somewhere along the way it's going to become viral. Most importantly, all of us, need to prepare a comment to submit to the VA before the cutoff, the 60-day cutoff, even if it might get extended. We have to act as if the 60-day cutoff is real. And that deadline is March 24th, 2015. Again, we've done sample skeleton comments where you can insert your own story. We've tried to engineer those comments around the top 10 that we think is the most offensive. But obviously, if you read the rule and find something else, by all means, comment on that. So we can help you, help your residents and your facility kind of fulfill the need for those comments. Also, let's get the word out. Facebook, LinkedIn. The hardest part about getting a response together is that people have no idea this is happening, and they wouldn't have any idea that this is happening until it's too late. And I can guarantee you they'd be hopping mad that veterans didn't have a chance to be heard about it. What are we doing now? Primarily, we are educating our clients and the families as to what's happening and what we can expect. But primarily, we have clients in kind of three buckets. Number one, the bucket of people who have claims that are pending right now. Those people, we are telling that, hey, let's get our application in as quickly as possible, and by all means before October 2015. So we're rushing to get people who have been on the fence to make a decision about things and get those pending claims going. It's so much so that we have cleared our schedule. My associate attorney and I have cleared our schedule as bare bones as we possibly can, and we're seeing as many families as we can, as quickly as we can. Now there's the bucket of people who have inquired about VA benefits but have done no planning so far. They've taken no steps so far. We are telling those families what's happening and telling them that it's possible that the bill or that the proposed rule could be enacted or effectuated with no grandfather clause, such that any planning that they're doing would be subject to a transfer penalty. And in that education process, I share with them the legal analysis that's been happening across the country as to whether it's constitutional to put a grandfather clause in or not. And I'll tell you, a lot of the families are saying, I don't think Congress would let this happen to us. And they're going forward with planning. There are also some families that say, I don't think Congress would do this to us, but let's go ahead and put the planning pieces in place, and we won't do our transfers until the rule clarifies itself, and then we will file our application in response to how the rule finally shakes out. The third bucket of people are people who are already on benefit. We're educating those families by saying, hey, listen, we think this is a remote possibility, but you should know that this rule has been proposed. There is no grandfather clause included in the rule. So the way it's written, it's possible they could come back to families who've already had benefits awards and take them back. So that's why it's so important that people speak up, because it's not fair that an agency just be able to make such a drastic rule change without congressional input, without public hearing, and with no regard to people who have done the planning according to the rules and grandfathering them in. So obviously, again, we just need to allow our voices to be heard. If you have any questions, Carlotta, did we get any questions typed in? If not, then you can do that right now.
I don't have any so far.
Okay, well, what I've done is I've recorded the audio portion of the webinar, and I have the slideshow. So if you would like to receive a copy of the recording and the slides to share with your organization or to share with your residents, reach out. I will absolutely accommodate that. If you know of someone who was not able to join the program today, let us know, and we'll get them that information as well, or we'll let them replay the webinar. We can send a link around. I appreciate everyone taking their time, and hopefully you kind of understand the proposed changes a little bit better and can put a plan of attack into place, a call to action, so we can get the word out. Thanks a lot, and have a good afternoon.